Good morning and welcome to the 11th meeting of the Rural Affairs and Islands Committee in 2025. Before we begin, could we ask everyone to ensure that their electronic devices are switched to silent? Our first item on the agenda is to decide whether to consider the evidence taken as part of its scrutiny on dog theft bill and this and in future meetings, and the draft report on the dog theft bill at future meetings in private. Are we agreed? Thank you. We now turn to our first evidence session on the dog theft bill, and I welcome our panel of representatives from stakeholder organisations. So this morning we have Chief Inspector Michael Booker from Police Scotland, Dr Paula Boyden, the Veterinary Director from the Dogs Trust, Laura Buchan, the Procurator Fiscal for Policy and Engagement from the COPFS. We've got Gilly Mendes Ferreira, the Director of Strategic Communications and Partnership Engagement, my goodness, from the Scottish SSPCA, and Mike Moore, the Policy and Campaigns Manager Scotland from the Guide Dogs for the Blind Association, and Stuart Munro, Convener of the Criminal Law Committee from the Law Society of Scotland. You're all very welcome. Now, I also welcome Maurice Golden, who is the member in charge of the bill, although I understand that Maurice is only going to be with us for a short time this morning. We have up to 90 minutes for the session this morning. So just before we start with the question, just remind you that you don't need to operate your mics. We have got a gentleman here that will do it for you. So I'm going to kick off with the first question. There's no official stats on the level of dog thefts either in Scotland or across the UK. However, Police Scotland provided data that there were 63 dog thefts recorded in 2024. Do we believe that's an accurate figure? And if not, what is the best available data indicating dog numbers and thefts and the trends in Scotland? Who would like to kick off? Maybe Michael?
I'll kick off if that's okay. Good morning, committee. So I don't believe that that's a true reflection of the picture in Scotland. The issue we've had in Police Scotland is our reporting and recording systems were legacy systems. So each geographical division had a different reporting system. What's just been updated last year is we now use one system. So going forward, it will be a lot easier to accurately record dog thefts in Scotland. So I don't believe that's an accurate picture of the situation in Scotland. However, going forward, I'm confident that we will have a more accurate picture.
OK, when you say it's not accurate, is it the figure likely to be a lot higher?
I don't have an answer for that.
And
that wasn't me.
Yeah, we're not allowed to say Alexa in here. So do you think is 63 an under-reporting of dog thefts, and what's the general trend?
I would anticipate it as under-reporting of dog thefts. You're under the common law crime of theft, unless there's a differentiation made on our systems. Those figures specifically for dog thefts will just be encompassed in that common law crime. So I do anticipate if this bill is successful, that if there is that differentiation, there will be an increase in reporting.
OK. Emma Harper?
Thanks, Convener. Good morning to you all. Just to pick up on that, in work that we've done over recent years around puppy trafficking and high-value dogs like French bulldogs, some of them that sell for a lot of money, and they're coming in from Ireland or whatever. And so do you think there's an increase because of the value of some of these dogs is really thousands of pounds?
There potentially could be. Our intelligence isn't telling us that. However, I'm sure that would be a factor that would have an impact. The most common breed to be stolen in Scotland is a bulldog, and I don't think that's coincidence. They are high value. They do sell for a lot of money, so I'm sure there is a direct correlation between that being the most popular breed for dog theft and the cost.
Thanks.
To comment, Gilly?
totally agree that I think it is an underreporting of what we see. From a Scottish SPCA perspective, we do get calls in where people are maybe looking to report some of that, obviously get signposted to Police Scotland. For instance, last year we had a total of 69 calls that came through. 46 of them were advice, so people looking for clarification on what they should do maybe. We did have 23 incidents, and this is where we have an overlap between ourselves and Police Scotland, where often it's actually a dispute between a couple where one's accusing the other that they've stolen their dog, and there's a welfare concern being raised about how that dog is being treated. So one of our inspectors would normally go, but then the kind of theft and that claim would be dealt with by Police Scotland. But certainly I would say it is an underreported figure, and that link with the sort of the organised crime side of things. The Scottish SPCA leads a UK and Irish pet trade task force. We actually just met recently. These are the types of things that we have discussed. There are certain breeds that are more desirable than others, and if that correlates with the breeds that are getting picked up that have been confirmed as being stolen, then yeah, not surprised by that comment.
So is there a sort of steel to order culture out there where organised crime will actually target pets on the street? And
social media and the widespread advertisement of puppies, certainly it's readily available, it's visible, so that will have an impact. The instances that we've had where puppies have been stolen, it appears to be from social media adverts.
Okay, thank you. Beatrice Wishart.
Thanks, Convener. Good morning, panel. I'm interested in how you think the bill might impact on animal welfare. Do you think the bill would have an impact on animal welfare? And if so, what would be your reasons for that? Could I go to Gilly first?
I think certainly this bill is very much focused on both, obviously, the human side, but there is the animal welfare side as well. We know the impact, and we've got plenty of research to show how important animals are to people, not just the adult owners, but to children as well. Again, I know I put in sort of written evidence about the importance of pets on children. We've done research with the University of Edinburgh with over 1,200 school-aged children between age 7 to 12 years old, and it came through really clearly how important that pets are in children's lives. 76% of children reported that their pet was their best friend, and 62% reported that they'd be lonely without their pet. And from the animal's perspective, obviously, if you've got somebody who has taken an animal, are they going to look after the animal properly? Are they going to provide what it needs? That's a traumatic experience for the animal. That's serious concerns from our perspective. So again, with this bill, you would expect that if somebody was charged with theft of a pet, there may also be charges under the Animal Health and Welfare Scotland Act if you could prove that that animal has actually suffered from going through that experience. So again, we certainly see the impact of both, and that's why I think this bill is very important. And the inclusion of those sort of victim impact statements, I think, are crucial as part of this bill.
That's interesting. Anybody else?
Echo that point. I think it's the current legislation under the common law crime of theft. For me, it doesn't sufficiently reflect the impact on families, the impact on children. It's not an item, it's a part of the family. So for me, that's a welcome part of the bill.
Laura?
Down off this morning, I would just like to reassure the committee that we do prosecute. It is a crime to steal a dog or any pet. It's a crime under Scots law, and we prosecute those cases under the common law. And in those circumstances, we do have information contained within the police report about the impact that that theft would have on a family, on children. And we understand, as a dog owner, I can only imagine the devastation if, to me, my children and family, if anything were to happen to my dog. But you can be reassured that that type of information can be shared with the court, and that the court can take that into consideration when sentencing. So I suppose going back to the earlier point in relation to the reported number of dog thefts, we don't see that number coming to us as reports. So it's difficult in terms of the data to then truly get a picture. So it's really helpful to hear the evidence from SSPC and police today about there being an under-reporting, and we see that in many offences. So I suppose my interest in the implementation of this bill, how that might affect an increase in reporting and encouraging people to report these types of offences.
Currently, as a criminal more likely to be convicted of an animal welfare charge or a theft charge in the event of a pet being stolen?
Absolutely be determinative on the evidence in each case. But I mean, as Gilly highlighted, we could also prosecute animal welfare offences along with the theft of a pet or a theft of a dog on the same complaint.
Okay. Thank you. We're going to move on to look at section 1 of the bill. And I've got a question from Evelyn.
Thanks, Convener. Good morning, panel. Some of the consultation responses to the draft bill noted that a standalone offence could result in a deterrent effect. Can you explain if you agree with this proposition? And if you don't, what are your reasons for that? You're all smiling at each other. Who wants to go first?
In perspective, I don't believe it would deter people. Looking at the cases that have been reported to us, there's certainly a degree of domestic cases where there's a dispute over ownership. That's going to be in existence, whether there's a specific bill or not. And in terms of those organised criminals who are perhaps targeting puppies for sale online, again, I think the monetary value would probably supersede any deterrent, I would say, from this bill specifically. However, what it does do is just highlight the impact and the significance of dog theft, particularly.
Stuart.
I wonder if I could come in. I'm Stuart Munro, the convener of the Criminal Law Committee of the Law Society of Scotland. I think one has to, first of all, consider whether or not deterrence is a factor that really has much effect in general in the system. I don't doubt that greater attention being paid to this as a social problem, greater concern being expressed by Parliament about the damage that this kind of conduct can have, has a benefit. Whether or not it would deter individual criminals from committing crimes is, I think, entirely moot. Laura made the point that the Crown doesn't see terribly many cases coming through in terms of reports from the police. And I think it's important also to remember this, that not every crime is necessarily comprehensively investigated. Not every crime necessarily has evidence that allows a prosecution, and not every case that's reported to the Crown necessarily results in a prosecution. There are all sorts of ways in which cases can, as it were, fall off that process. And so one sees relatively few dog theft cases coming through to the court. But another point is this, that those that do often end up being prosecuted on summary complaint in very busy courts. There's actually very little time devoted to individual cases. But I think I go back to Laura's earlier point about sentencing. We already have a clear sentencing policy that judges require to apply in any criminal case. And one of the important issues is what harm has been caused by the offence. And one would hope that in cases where there had been real harm experienced by family members or indeed by the animals concerned, that that would be communicated and that would be taken into account by the judge. No doubt specifying a separate offence distinct from the common law charge of theft would allow greater attention to be focused on that. No doubt it would enable the police to collect better data on how prevalent this is. No doubt it would enable Parliament to properly monitor the effect of the legislation. But fundamentally, it requires resources. It requires money to be spent in investigations, on prosecutions, and ultimately to give these cases the time that they deserve.
Anyone else? Laura?
I agree with most of Stuart's points in relation to the cases that come through to us, and we can only prosecute cases where there's a sufficiency of evidence. What I would say, I've been a prosecutor for more than 20 years. I have seen a small number of cases of dog thefts come through the courts, and when there are cases, any cases involving animals that are before the courts, my experience that they are treated with consideration. They're given thorough consideration and the facts and circumstances are laid by the court, and that's by the defence, by the prosecutor and by the sheriff who's dealing with the case.
Okay. Paula.
Paula Boyden, Veterinary Director at Dogs Trust. I think from our perspective, I agree with Police Scotland. I think with serious crime, it perhaps wouldn't be a deterrent. However, I think having this as a standalone crime will really reflect the seriousness of it. You'll be aware that we now have a sentience bill, so recognising that dogs are sentient creatures, which means not only can they experience pleasure, but they can experience pain, they can experience distress as well. And interestingly, we are starting to see prosecutions of the emotional abuse of dogs because of the abuse they have been subjected to. So, and I think, in terms of them being a member of the family, just because a dog tends to walk on 4 legs rather than 2, it does not mean to say that, in times of illness, in times of bereavement, the feelings are just as intense. And certainly with my experience of working in dog welfare for many years, if individuals don't understand the strength of that bond, they're not going to give it the right attention. And we've seen this with sentencing with animal welfare offences. It's just a dog. It's not just a dog. It's a member of the family. And I think it gives it the right standing to have that standalone bill.
Thank you. Gillian?
Yeah, again, I would completely support what Paula has just said. And I think having it as a standalone offence, we have seen that, yes, organised criminals, they will go and they'll change tactics. One of the tactics we are now seeing through the trade is that they are utilising quite vulnerable individuals to play host to a litter of puppies and sell out of their home and do other things. And again, when you have a standalone offence like this, it puts that seriousness of not getting involved and caught up into these types of situations. So yes, while it's not make a deterrent against the organised criminals themselves, those that they are now seeking to support their activities by having this offence would actually raise hopefully that kind of bar of not getting involved and not facilitating those types of activities. So I do feel that it's really important to have a standalone offence.
Okay, thank you. Rhoda Grant.
Thank you. Chief Inspector Michael Brooker talked about the reasons why reporting and data might not reflect the true nature of the crime, and we see that in England and Wales as well, where crimes are estimated to be below 5%, and I wonder if the same reasons are in England and Wales of how it's being recorded. But I also wonder if the bill itself will make a difference to not only the recording, but could we see recording going up but incidences fall because of the impact of the bill, or is there something we should be adding to the bill to make it more impactful?
We would always encourage reporting. For me, and from Police Scotland, for us, it's a change in legislation rather than a change in practice. We always encourage people to give us intelligence, report that incident, so it is recorded. As I explained earlier, the new reporting system will help us to give us a true picture in Scotland. I think that the introduction of the bill would certainly highlight, I think, to victims and reporters that there is a focus on this type of crime. I think occasionally the feedback from victims, from reporters, is that because it's a common law crime of theft, they don't have the confidence that there's enough significance placed on the theft of the dog. So I do think that that's where the bill would just highlight that we are treating this seriously. We will investigate it thoroughly. But from our point of view, it's not a change in process, it would be more a change in legislation.
In perception?
In perception, absolutely.
Anybody else? No? Tim?
Thank you. Good morning, panel. I just want to go back to the standalone offence part. So other acts, have created a standalone offence. One of those, as an example, is the protection of workers, retail and aid-restricted goods and services. You might not know that one, but that's aimed at protecting retail workers. So I suppose the question is, what, if anything, would change in terms of the investigation or the prosecution of offences following the introduction of a standalone offence?
That's a very good example, and I think, as Chief Inspector Michael said, that from a prosecuting perspective, the prosecution process would remain the same in terms of the evidence that would be required to show that there had been a theft and corroborated evidence. So, and And that can, I suppose, in relation to the retail provisions that you've highlighted, means that there are options available to prosecutors as to how they prosecute an offence, which means it can also then make it more difficult to have the data available, because some will be prosecuted under one part of the legislation and some may continue to be prosecuted under the common law. So I don't see any change in the way that a prosecutor would consider a case in the manner in which it was reported. We would still approach the case in the same way.
Okay. Anybody else?
Point of view, it wouldn't change our processes. The only additional piece of demand that it could place on officers is obtaining that victim impact statement. And the true impact of that is still to be seen, because we don't have the true figures available. So it's difficult for me to say what the actual impact of that would be, but it would certainly be an extra demand on officers to obtain those victim impact statements. Also, in terms of the new bill being introduced, it would require additional training, which again would be an impact. But in terms of investigations, it would be the same investigative process.
Thank you.
Okay, Elena.
Thanks, Convener, and good morning to the panel. The use of the term abduction within the UK Pet Abduction Act 2024 switched the focus from the loss to the owner to the welfare of the animal. In current common laws, as already been outlined this morning, and under this proposed bill, the victim of the crime of theft would be the dog owner. Do you have any views on the use of theft versus abduction in terms of investigation and prosecution? And I could start with Laura, maybe.
Again, from a practical perspective, I don't think it would make a difference to the way we would approach the case in terms of the evidence required to prove either theft or an abduction. So in one view, I don't consider there would be any difference as to the term. I can understand, I suppose, emotionally, if that's the right word, the words make a difference, perhaps relating to the evidence that Paul has given this morning.
I'm just trying to figure out if in the UK context there was a decision that was made actually to focus on it being abduction, which feels like a very different type of language and word to use versus theft, because abduction then does put some of the kind of context onto the actual abductee, which in this case would be the dog. So that was the kind of the gist of the, where I was coming from, but you're stating that it actually neither of the two would have any difference as to how it would be investigated or prosecuted.
Not that I can consider at this stage. How the courts might interpret that in terms of sentencing, I couldn't comment on either.
One of the questions that I was wondering about, as somebody that worked for Women's Aid for over a decade, is that there's definitely instances of coercive control under the Coercive Control Act and domestic abuse legislation that we have that recognises that instances of theft of pets or harm to pets, especially dogs, is related to the perpetuation of that coercive control and domestic abuse. And I'm just wondering if there would be any way that the proposed bill could be strengthened in that regard, or do you think that the existing legislation that we have takes on the seriousness of that perpetuation of coercive control by theft of dogs?
I think that's very important as well. I think, again, what I would say is the domestic abuse legislation that we currently have in Scotland is really strong. And we do see and we do now narrate and record and libel instances of that type in relation to coercive control. And we can see that pets, whether it be dogs or cats, are used in that context, but they should that should properly be libelled within the domestic abuse legislation.
Yeah, Paula.
Thank you. So, as you'll be aware, Dogs Trust runs Freedom, which is a pet fostering service for dogs belonging to people fleeing domestic abuse. And I think this legislation could be strengthened. I certainly have reservations around this proposed bill not applying to situations where two people have lived together exactly for the reasons that you mentioned about coercive and controlling behaviour. I also chair a small group called the Links Group, where we raise awareness of the link between abuse of animals and abuse of people, and we know the lengths that perpetrators will go to have a negative impact on the victim survivor. So this is of concern. For example, we have had perpetrators have pets euthanized before. We have had them kill pets before. So that's something that really does need to be addressed within this. It's a significant concern that we should be able to address it. And although pets are now mentioned within the Domestic Abuse Scotland Bill, it's very much focused on the behaviour of the perpetrator. So in terms of not feeding the dog, but I don't believe there's sufficient protection for pets within the domestic abuse legislation. Interestingly, I was at a meeting at Westminster yesterday where there's a proposal for a new law called Ruby's Law, which is to actually bring pets into non-molestation orders and also within accommodation. So again, reflecting that pets are not sufficiently accommodated within domestic abuse legislation.
Okay, that's very helpful. Thank you very much, Paula. Thank you for that.
So, yeah, the SSPCA highlighted the calls that it's received about dogs involved in domestic breakup. So what's your view of Section 1(2), the defence that an offence is not committed after a relationship breakup?
To fully back what Paul has just said, the cases where we have had to step in because there's been welfare concerns around that individual animal, that is very hard to prove then the ownership, and particularly if it is in that situation where there's coercive control going on. We see it also, again, where we are involved in animals of non-accidental injury, perpetrators have vet shopped. In effect, they've bounced between different vet practices, animals disappear, and I feel that is one part of this bill that it does definitely need to be taken into consideration, because I think it would make it stronger, but also it recognises that you will be in situations, as we already have been in practical terms, where that ownership dispute is going on, and that's where this bill could actually be really strengthened to help address that, in line with other offences under the Domestic Abuse Scotland Act and the Animal Health and Welfare offences.
Okay. Michael, did you come in?
I would absolutely echo that. I think domestic abuse situations, Police Scotland will thoroughly investigate those circumstances and get to the bottom of what's caused that situation. Absolutely, as Gilly said, it's a lot of these domestic disputes over ownership. I would welcome more strengthening in this bill in terms of clarity on how we actually prove ownership, because that is a difficulty that we're experiencing as well.
I would urge caution in conflating domestic abuse and relationship breakdown. There are plenty of relationships that break down where there has been no domestic abuse. And the idea of, as it were, bringing in the police to regulate issues of property ownership where there is no domestic abuse is a very substantial step. Identifying ownership can be incredibly difficult. You have a couple who live together, they decide to go and buy a dog, they assume their relationship will continue permanently. It doesn't. Who owns the dog? These are issues that even our civil courts don't find easy to resolve. If you have a situation of a married couple or a couple who are cohabiting, so they have similar sorts of rights, that is an issue that often has to be dealt with in a civil court in the same way, whether we like it or not, in the same way as other property belonging to the couple is dealt with. There are interesting questions as to the extent to which the welfare of the animal ought to be taken into account in those kinds of issues. And we're beginning to see movements towards that in the family courts. But the idea of, as it were, people having recourse to the police purely to resolve what are fundamentally property disputes is, I think, a pretty substantial step.
Laura?
Yeah, I agree. I think we need to be cautious about legislating and thinking that will resolve the issues in terms of proof, because the proof is always a difficult part in terms of ownership. And that won't change in terms of the evidence that's available. And just to reiterate that there still are, in my opinion, there's no legislative gap, which means that we can't adequately deal with those situations with the current provisions that we have. If there's a gap, it may be in the evidence that's available to prove types of these offences, but that won't be remedied by further legislation.
Thank you.
If I could just respond respectfully just challenge that is, you know, I do understand in terms of straight property, but when you're dealing with domestic abuse, it's a very, very different situation. Just understanding how perpetrators work, that they will quite often buy a pet for their victim, allow them to develop a bond, and that's when the coercive control starts. So, for example, quite often perpetrators will register the dog in their name at the vet. They will register the microchip details in their name. So, for example, when we bring dogs onto Freedom, we will actually lock microchip database details down because the perpetrators will not stop at any length to try and find out where the dog is. Not particularly because they want it themselves, but they do not want their victim to have it because of that bond. So I think we cannot underestimate the domestic abuse instances. I agree in straight ownership disputes, but in domestic abuse, it's a very, very different situation.
Rhoda?
Do you think this bill is where we deal with that? Listening to both sides of the argument, it seems very complex. Could we deal with it in this bill? Is there something we could put in that would, you know, because we have the ability to amend at stage 2, is there something that would be useful to put in the bill? Or should it be in domestic abuse law, but we don't have a vehicle to do anything at the moment with that?
I think it size fits all. You know, it's great that we now have pets are recognised within the domestic abuse legislation. It could be strengthened. I've mentioned Ruby's law. I think within this bill, perhaps a modification of the wording that in general ownership disputes, absolutely, this shouldn't apply. However, there should be an exemption where we know that there is domestic abuse because of the coercive and controlling nature of those situations.
It's helpful, thank you.
Ariane Burgess.
Thanks, Convener. I just wanted to come back on the, before I ask my main question, which is around penalties, I just wanted to come back on Elena Whittam's question around abduction and the use of abduction, or theft rather than abduction, and get clarification on, abduction was used in a UK piece of UK legislation, but I just wonder if we have a specific definition in Scotland around abduction that may relate to people rather than pets or things. Just wanted clarification on that. Is that maybe why we've gone with dog theft rather than abduction? Just to get clear on that. Laura, you're nodding your head, so...
I'm nodding my head to see if it assists the committee. What I can do post is to submit a paper or a letter outlining the current law in relation to abduction and theft, and comparing that with theft, so that you have the full definition before you.
Mm-hmm. But is there anything you could say about it now? Is there a specific use of the word abduction, and that's why we haven't gone with it?
I've only ever seen abduction ever used in relation to people.
Right.
I would have to go back and look at the common law to determine whether that prevents us from using abduction. It may not. We might just simply never use the law of abduction in relation to pets, but it may be that following the common law that it's always been people that we've referenced when in using the law of abduction, and theft has been commonly used in relation to the theft of pets. But
a couple of points, and I absolutely echo Laura's suggestion that that's something that is looked at and responded to, because these are not simple concepts. Just two very brief points. One is, I think when you start talking in terms of abduction, you potentially bring in issues of consent, which may complicate matters unduly. And secondly, I'm reminded of what we used to libel in cases involving children, the old common law offence of plagium, effectively the theft of a child, when really what we're talking about is abducting a child by a parent. Now, I couldn't say how often that is libel these days and how the Crown deals with it. But these are complicated issues that need to be looked at very closely, I think.
And I could imagine that my colleague Maurice Golden looked at it pretty closely in his process of developing the bill. It'd be interesting to ask him those questions when he comes in front of us. I'm going to move on to... Not now, exactly. This is just your warm-up. Yeah, so I'm going to move on to a question around penalties, and I think maybe I'll direct it to you, Laura, in the first instance, and then open it up as to who wants to come in. So I'd be interested to understand what your views are on the penalties included in the bill, and would you expect the provisions in the bill to have any impact on prosecution or sentencing where the new offence was used?
So all the penalties are currently available in relation to the common law offences that are there. So it would be determinative upon when, where, in which court the prosecutor would progress proceedings, whether that's in the summary court or the solemn courts. But as it stands, all sentencing options would be available.
On that penalties question? No? Okay. I've got another one, which is that I'd be interested also to understand if, and maybe I'll go to Paula, if you believe the proposed sentencing framework would allow courts to properly reflect the emotional harm experienced by victims rather than just the monetary value of the dog.
I think this is why we need things like the victim statements to fully understand that. And certainly with sentencing guidelines, there is a part of that includes the value of the pet, and that I don't think reflects the impact that the theft has. So, for example, my own dogs were adopted from Dogs Trust at however many, a couple of £100. You know, my emotional tie to my dogs is no different to somebody who's paid £3,000 for a dog, and therefore using that as a mechanism for sentencing really does not reflect the seriousness and the impact of the crime.
So just to clarify, so are you saying that you'd like to see the sentencing guidelines explicitly account for the sentience of the dogs to help ensure consistency and recognition of the bond between the owner and the animal?
Very much so.
Yeah. And Julie, do you want to comment on that?
Yeah. No, agree that, and I think the sentencing guidelines really need to include that. What we do see, and it's probably a debate for another day, is that actually the inconsistency in sentencing at the moment of current legislation. Sometimes when we have cases that have gone through, the sentencing that comes out doesn't meet our expectations, and that's something again that we'll be taking up and sort of looking at the sort of overarching sentencing guidelines. I think there's an opportunity here to set that kind of bar of bringing in the victim, the emotional impact that these are sentient beings, and I think that is where this will have a really good opportunity. But those guidelines are so important. When these cases come to court, I mean, they are dealing with a whole raft of legislation. Animal welfare legislation won't be something that they use routinely, which is why we're very keen to address the guidance that are given when it comes to animal welfare offences, because we are seeing quite significantly a lot of inconsistency in sentencing on current legislation. So would not want to see the same happen with this.
Okay, thanks. Stuart, come on
in. Come in on that. Just to be clear, we have very little in the way of sentencing guidelines in Scotland. There are 2 or 3 specific guidelines for particular categories of case, not including this, and there is a general sentencing policy or sentencing process policy guideline, which was the one that I referred to earlier, and I think Laura did as well, where there has to be some quantification of the harm caused as part of working out how serious a crime is and what the penalty should be therefore considered. What we don't have is any explicit sentencing policy whatsoever in terms of theft, and certainly not in terms of theft of animals. What might have been referred to by Dr Boyden is the English Sentencing Council guidelines, which are far more extensive, and that reflects the different approach that we've tended to take in Scotland as against England. It would be open to the Scottish Sentencing Council to consider making guidelines in connection with theft or dog theft cases, or indeed under this legislation, but that's not something that would happen automatically. And while I think the Sentencing Council here is looking at expanding the range and utility of sentencing guidelines, it's got quite a lot of work ahead of it.
To reassure the panel and the committee that there are other ways that are utilised other than the victim impact statement scheme, and the victim impact statement scheme currently is only for legislated offences and for offences that are in the solemn court, and for not all offences within the solemn court. But that doesn't mean that in courts across the country we are day in, day out telling sheriffs about the impact of crime. We're telling sheriffs about the emotional impact of crime, so that can be taken into account into sentencing. So that there is still that ability there. I think Stuart's point in relation to sentencing guidelines is a good one too, and I understand Gilly's point about the concern about the different sentencing that's available. And ultimately that's something for judiciary and for SCTS.
Emma Harper. Oh, I beg your pardon, sorry. Ariane, do you want to come back in?
Yeah, sorry. I just want to come back in on the sentencing guidelines. So, Stuart, you're saying it's not something that we have much on. So, are you saying that it's not a kind of door that we want to open and start creating a precedence or for sentencing guidelines? Or
I think it's for Parliament ultimately to decide what the range of penalties should be for particular crimes. That's in Parliament's gift. But generally what happens is once a crime exists, it is for the judiciary to make decisions about sentencing. We now have a move towards a greater structure in that process. Traditionally, we would leave it all to the discretion of judges. The Scottish Sentencing Council is beginning to erect a framework within which judges are expected to operate. But it's a very different picture to that in England and Wales, where there is an altogether much more comprehensive structure of sentencing guidelines, where effectively it becomes almost formulaic in the way in which it's applied. And that's not really the position that we've had here. All I'm saying is that what the bill proposes is to create a new offence that maps onto an existing common law offence with identical sentencing powers. So in that respect, it doesn't change anything. Changing sentencing policy is a different matter altogether.
thanks, Convener.
Thanks. Emma Harper.
Thanks, Convener. It's just on the issue of victim impact statements. Does this propose to create that, and then, okay, it's mandatory that a victim impact statement would be provided, but does that mean that in other law cases that impact statements might then don't get provided or do, or is it a choice, or does this create a difference in the current law then, that if you mandate a victim impact statement for this dog abduction, then, but it's not required or mandatory or in other criminal cases?
If I may come in on this point, I think it's a point we highlighted in our submissions, that currently the victim impact statement scheme only relates to solemn cases, so the cases prosecuted in the Sheriff and Jury Courts are High Court cases, and not all solemn cases. So the cases that it currently covers include cases involving violence, sexual offences and housebreaking. So in relation to the provisions of this bill, it would mean that a victim impact statement would apply to the theft of any dog and be prosecuted in any court. So you could have, I suppose, the anomaly of a victim of domestic abuse in the summary court is not entitled to a victim impact statement, but the prosecution of a theft of a dog in the summary court would have a victim impact statement. So it's about, we absolutely are in support of victims being able to provide victim impact statements and the courts being able to have that information available, but it's about being able to ensure that we're creating that in the right way. Last week there was discussion at the Criminal Justice Committee in relation to the Victims Witness Justice Reform Bill about amendments that were proposed in relation to victim impact statements for cases. And the Cabinet Secretary for Justice talked about her hope to expand the scheme, but looking at firstly expanding that in a staged way which would look to cover all victims in solemn offences. So I suppose there's two things. One, again, reassurance that that information can be provided in another way. It's not that that information is not provided by the court, but that this is a separate scheme. But the way to increase the scope of offences which are covered by the Victim Impact Statement scheme is to amend the legislation where you can include the offences that are covered. So that, I don't know if that's explained it, but that it is a scheme. So in terms of rolling that out, there's currently no process in the summary process for obtaining victim impact statements, for considering victim impact statements, for providing those to the court. So this would require for a separate process. And again, quite distinct from the separate process, you might just find that, you know, victims of stalking in solemn cases don't yet have the ability to provide victim impact statements in solemn courts. So it was just to highlight that to the committee in terms of the specific provisions in this bill.
And a victim impact statement is, it could be written, it could be in private, it can be presented in court? I mean, is there a hierarchy of what would be required that then means that this makes it more complex in order to define?
So the only difference in terms of we can provide all the information to the court, whether it be through a victim impact statement or whether that be by us providing the information to the court, or if a victim's giving evidence telling the court about the impact that the offence has had of them. But in terms of the legislative perspective, it places a duty on the court that the court must take that victim impact statement into consideration when sentencing. Now, courts will take all the information before them into consideration, or should take all the information before them into consideration of sentencing. But the scheme places a duty on the court to ensure they're considering that when they're determining sentence.
Okay. Okay.
Can I just briefly echo Laura's point? This is information that one would ordinarily expect to be collected and passed on anyway. Even if you don't have a formal victim impact statement within the terms of the scheme, the police will be asking, or should be asking, the victims of crime what the impact has been. They will be recording that. They'll be passing that on to the Crown. If the Crown makes a victim or a complainer aware of the fact that there is a prosecution underway and the complainer contacts the Crown, say, look, I just want you to know this is how this has impacted us, I would expect the Crown would pass that information on at the point of sentencing. The sentencing process guideline makes it entirely clear that that information would have to be taken into account in the assessment of the seriousness of the offence. So while a victim impact statement is another layer on that, it really replicates something that should be happening already.
Okay, thanks.
Emma Roddick, do you have further questions on the statement? Thank you.
I did want to press on the victim statement issue, particularly having read the COPFS submission. In terms of the crimes which currently victims can make use of this, do you see any potential impact on how seriously those impact statements are taken in those proceedings if they are to start being used in different courts?
No, I can't see that. I think in Stuart's point, it's just another way and mechanism of having the impact statement put before the court and considered by the court. I think we simply wanted to highlight the offences for which the scheme already covers. There are ongoing discussions between criminal justice organisations and Scottish Government about how that scheme might be extended. And the offences that it might cover. So that's the opportunity for us to have ongoing discussions, I suppose, with representatives around the table to ensure that they are involved in those discussions when we're looking at expanding the scope of, or when Scottish Government and Parliament are looking about expanding the scope of the victim impact statements. But there are, as you can see, it currently is quite a limited, to a certain extent, scope that victim impact statements cover, albeit a large amount of cases before the solemn courts are sexual offences. But there are other types of offences one would hope would come under that scheme in due course, but it would require to be in quite a staged and managed way to allow that expansion to be successful.
And in terms of that expansion, are there other crimes that you would think should be the next part of the stage managed process?
I don't think I could prioritise the types of crimes, but I think there are some serious crimes. I spent a long time with oversight of deaths investigations. So those who were killed or injured, say, as a result of health and safety offences. Families in those situations or loved ones don't have the opportunity to provide a victim impact statement. They can, of course, their position can be, again, put to the court when those offences are prosecuted, and a sheriff or judge can take them into account. But there are a large number of offences that one might want to consider should fall within that scheme in due course.
Thank you.
Now I'm going to look at section 2. I'm going to bring in Mike Moore for any thoughts on aggravation for theft of assistance dogs. Have you any general views on that section?
It's something that we at Guide Dogs would support, I think, in terms of the present bill. That's a provision that it wasn't part of the Pet Abduction Act that was passed in the UK Parliament last year. So in that sense, it would make it would put Scotland in a position of having the strongest legislation in the UK in terms of handling thefts of assistance dogs. Now, I would stress that at guide dogs, we don't have any recorded cases previously of dogs at any stage of their life, working partnership, puppy, or so on, having been successfully stolen. There have been attempts made, and we know that it would be immensely impactful to either a guide dog owner or a puppy walker, or indeed members of our own staff, if a dog was to be taken, not just because I think, you know, but even with bearing in mind the fact that the bill is aiming to decouple the value of a dog, a pet dog, whatever, from the true emotional, psychological impact. I think whenever you look at the resources, taking into consideration the resources to train a guide dog, match it with a blind or partially sighted person, and then the associated costs of insurance, vet bills and so on. It is quite a substantial resource investment, but that does very much fail to, I think, account for the difficulties, the challenges, and the impact that would be experienced by a guide dog owner if their dog is taken. Not to detract in any way from the value and the importance of pet dogs. They are very much family members. I have one, so I'll sort of speak from that basis. But I think guide dogs, and there are other assistance dogs as defined under the Equality Act, but guide dogs are uniquely difficult to replace as mobility aids, even for people. A lot of the, I think a lot of the understanding of why a standalone offence would be helpful in Scotland does come down to weighing the value of a dog as a sentient being against, you know, arguably any random possession that might be taken from a person. But I think, you know, with people with sight loss, you could compare it perhaps to the loss of having something like a long cane stolen, or a technology, a device, assistive technology like a laptop or a tablet with screen reading software, something like that. The bond and the companionship with an assistance dog for somebody with sight loss, but also the resource that goes into training and creating that partnership, and also the significant difficulty in replacing a guide dog in a case where it would actually be stolen and not be able to be reunited with its owner, I think does justify this provision being in the bill.
Do you think that the inclusion is going to achieve something that cannot be achieved under common law theft offence?
I think that in terms of the aggravation for the theft of an assistance dog, I think some of the same points that have already been covered in relation to Part 1 of the bill apply, but I think in considering the impact of the loss of an assistance dog to somebody, much in the same way that pet theft, it's very difficult to see how that can be treated in the same way as the theft of any other possession from somebody. With the points I've just made in terms of the value and the difficulty in replacing an assistance dog, we do see it as important that the courts make a distinction between assistance dogs and pets for those reasons. I think looking at the broader legislative context as well, there might be, in terms of the motivation for stealing an assistance dog, and it could happen under any number of contexts. It could be a puppy in training to become a guide dog. It could be a working guide dog who is harnessed up and out in the community and working with its owner, or it could be a working guide dog that is off lead in an exercise area, free running, that kind of thing. There are different contexts which may or may not indicate greater malice towards a disabled person in depriving them of an assistance dog. But I think in any of those cases, we would very strongly agree with the view that it ought to be treated more severely than the loss of a pet, and the aggravation would certainly help to prosecute in a stronger way than the current common law allows. And I think maybe we'll come on to questions about that. I think there's relevance in terms of the ability of victims to make that impact statement as well, in terms of the loss of an assistance dog.
Yeah. Paula?
We'd completely agree that there should be an aggravated offence. I don't believe that common law theft really, it totally underestimates the importance, firstly the sentience of the dog, but also the impact of that loss. There was one study looking at people living with mobility or medical service dogs. 98% of them described the benefits of their dogs, not only in the assistance they provide, but also that companionship. And that's not just for that individual with the supported person, but their family, the emotional benefit, the sense of confidence, motivation, and the social benefits of having an assistance dog. So it's much broader. I've heard them described as equipment, and they are way more than equipment. And I think this reflects that.
Julie?
Yeah, again, in total agreement. I think the theft of an assistance dog, you are impacting that victim's independence and their quality of life ultimately. If it's a dog that's involved in sort of medical support, you are risking that person's life if that dog is not picking up on the warning signs that they're trained to do. It's not a quick thing to train dogs to facilitate the different needs that are required to become an assistant dog. So again, as well as the immediate impact on that victim, there's actually a longer term impact as well, whilst they get matched with another dog. And again, bringing that into your point, Mike, about the cost around that, it takes time. It's not a simple thing. You can't just get one of the puppies out there to grow up faster and get them back into the community to support somebody. So I do feel very strongly that it should be a separate and an importance played on that, because ultimately you're impacting that person's independence, their quality of life, and potentially also their health from a medical perspective as well.
Thank you. Michael?
Regards to assistance dogs, is while this bill looks to make an aggravation for all theft of assistance dogs, my only consideration or point to raise is if that dog isn't obviously performing the role of an assistance dog, should that aggravation still apply? I completely agree that there is a huge difference in distinction between a family pet and an assistance dog. But for example, if that dog isn't wearing a reflective vest to identify it as an assistance dog, and the offender doesn't know it's an assistance dog, should that still qualify as an aggravation?
Laura?
I think, again, it's just about whether this legislation achieves something that can already be achieved under the current legislation. And I absolutely understand and agree with the points that you've made about the importance and significance and how, heinous it is for somebody to steal an assistance dog. And I'm grateful for Mike giving us some idea. I've never seen an example of an assistance dog's been stolen. That's not to say that either has not happened or could not happen. But I think the point raised by Michael is a good one. I think we would have to be able to demonstrate that the accused knew that the dog was an assistance dog to be able to prove the aggravation. Now, that might be easily able to prove. And the point of the aggravation is that a sentence that the Sheriff does require to consider an aggravation when determining sentence. But again, as we've discussed earlier, a Sheriff can also do that by giving the full circumstances and the impact. Now, that's something that we perhaps in these situations, if and when we have a report of an assistance dog being stolen, we should be properly seeking information, be made properly come to organisations to understand the impact so that that information can be provided to the court and then properly considered when determining sentence.
Stuart?
Yes, thank you. I agree pretty much with, or I understand entirely everything that Mike said about the particular impact on those who depend on assistance dogs when something like this happens. And of course, that is crucially important. Of course, that should be reflected in any disposal that a court might ultimately make if this case comes before them. I am in no doubt about that whatsoever. I simply say this, the sentencing process is already structured in a way that should allow that information to be properly taken into account. Now, sure, that depends upon the information being collected. It depends upon the process by which that is ultimately put before the court. But again, coming back to the sentencing process guideline, some of the things that it says require to be taken into account in terms of assessing harm include an especially serious physical or psychological effect on a victim, just what Mike has really been describing, I think. And in terms of existing aggravating factors, in terms of the sentencing process guideline, the deliberate targeting of a victim who's vulnerable or perceived to be vulnerable. So if you have an issue of somebody actively seeking to steal an assistance dog, then that too would be something that our existing law reflects as being worthy of a more serious penalty. Put it another way, if this bill were to pass, and if there was an instance of somebody stealing an assistance dog, would the new formulation of the bill necessarily lead to a different sentence being imposed than if the case was prosecuted under the existing common law? I don't really see any reason why it would, provided the same information was provided to the sentencing judge at the appropriate time. But if the committee and ultimately Parliament is of the view that dog theft should be a separate standalone offence, the notion of theft of an assistance dog being treated as a formal aggravation is one that I would have no difficulty with.
Okay, thank you. Emma?
Thank you, Convener. Can I press that a little bit further with yourself, Stuart? I'm picking up on, it sounds to me like a little bit of a contradiction in the use of language around why this bill is necessary for the theft of a dog being the theft of, a family member, a more emotional thing, and then moving back when it comes to guide dogs, accepting that guide dogs can be part of the family as well, more about the equipment side of things that can currently be sentenced. So is there that confusion there, or do you think that that could arise should this bill pass? Is there a contradiction in approaches that might complicate?
I don't think so. I mean, of course, a dog can be both. It can be a loved part of the family and a very valuable assistance dog. And both of those factors can, as matters stand, be taken into account, should be taken into account by a sentencing judge were the matter to come before him or her. If the bill were to pass in its current form, and this was to be a statutory offence with an aggravation, there's still no reason why the court couldn't take into account the additional family impact, or, for that matter, the impact on the dog itself. There's a wider debate about how we treat animals in our system as a whole, not just the criminal justice system, but how we treat dogs in family breakdown, how we treat minimum standards of welfare of dogs, a whole range of issues that involve this kind of deeper question of the dog as a sentient being. But in the context, obviously, of what we're looking at the moment, namely the criminal justice system where you have the theft of an animal, the theft of a dog, I think our system currently allows all of these potentially complex, sometimes conflicting considerations to be weighed in the balance and taken into account. And ultimately, whatever the framework, that is still going to have to be done by the judge who comes to sentence in the case.
And then just kind of open to anybody, thinking about the argument that, you know, guide dogs are really hard to replace. They have to be trained, they have to be matched to the person that they support. Does this apply also to other working dogs? And is there an argument for an aggravation for other types of trained dogs?
And I think, again, the definition of an assistance dog, you'll be probably all familiar that, and we've certainly seen it through our Animal Guardians programme, which supports children who have harmed animals or shown behaviours towards that are cause of concern. We are seeing now a lot more of I suppose, support dogs, or dogs that are there for emotional support and so on. And again, you would argue the same impact. So we have young people in schools now who actually, some do take dogs in to support them with anxiety about being in social situations. That's a good example. So that definition, that was one thing I was going to do as a challenge of this, is what's that definition? I know we've obviously referenced it specifically, what's laid out in other legislation just now. It'll be maybe helpful to the committee. I will pass a research paper that there was about 100 of us around the world trying to get definitions of these different categories of how animals are used. So I'll share that as a follow-up to this. But certainly I think when it comes to, there's dogs for different purposes and they will require different training, and that definitely needs to be taken into consideration, I think, for this specific purpose, and that definition, I think, does need to be looked at as part of this bill.
Yeah, Michael?
That definition, that would be essential, I think, for us if the bill is passed, and that I think if people know that this is an aggravation, then we could be in a situation, if there's no clarity around the definition of assistance dog, that we could have everyone saying that it's a therapy dog and it's not. So that definition would be greatly welcomed by us.
I suppose the member's not here, but it's certainly something that we'll ask him about. It would appear that the thrust of this bill is very much about the personal, the connection that an individual has with that animal, whether it's an assistance dog, whether it's a companion dog or a pet, which does raise the question of whether Shep, the collie, that's the working sheepdog, should be recognised in some way, because you know, if a shepherd was to lose his collie, that would have a major impact on his ability to do his job. But that area is not touched on at all. It feels like the bill's very much about the emotional impact of victims and how to address that. Is that something that we should be looking at stage 2? You know, reference to working dogs, not just assistance dogs, and you know, someone's ability to carry out their day-to-day work. Gilly?
I think ultimately it'll probably actually come to that from Michael's point of when you're actually in that investigation state and somebody is quite rightly advocating the impact that for whatever purpose that dog has been used for, that I think will become more complicated if those definitions don't exist. So someone quite rightly be saying, my livelihood depends on me having that working dog out in the field, doing the job that it needs to do. I don't have that dog anymore. That's impacted my livelihood, plus all the emotional impact as well. And that would be something that the police would then have to be, right, okay, back in that definition space and relate it back to this bit of legislation. So I do think that needs to be looked at.
Beatrice Wishart.
Thanks, Convener. Just moving on to sections 4 and 5 are about the annual reporting and review. Section 4 requires Scottish ministers to report annually on the Act, and Section 5 requires Scottish ministers to review the Act 5 years after it comes into force. I just wondered if you have any views on that. Anybody want to take that? Yeah.
As I explained earlier, now with our new reporting and recording system and it being a national system, I'm confident that those reports will be more readily available and there'll be a true reflection of what's been reported, so I would welcome that.
Julie?
Yep, likewise, I would welcome that, and I would welcome the 5-year review. We're obviously just about to hear the 5-year review of the Animals and Wildlife Penalties Protection Powers Act, and we've obviously contributed evidence to that. So again, particularly when it's something quite new, that you should always have a review period, and you should look at how that's working in practice.
As well, I'd also like to see within that review some greater detail, which hopefully would be available with the new recording system, of things like breeds of dog, particularly if we're looking at potential organised crime and the such like. So what are those trends, which I think would be incredibly helpful.
And the data would be available from our systems in terms of any review, depending on, obviously, human ability to put it into the system properly.
And finally, every piece of legislation ultimately comes with a cost. It's just to ask whether there's any views on the financial memorandum and how that might be applicable to your organisations. Has anybody got any comments on the financial memorandum? Michael.
It's really difficult for us to predict what the financial impact will be. If the bill is passed, there'll be the legislative learning, I suppose. Training our workforce, making sure that they're aware of what the legislation is and how to apply it. But it's really difficult to know the scale of that without accurate data and without the hindsight of how this new bill may increase reporting. So there will be an impact for us, but it's difficult to actually assess what that would be.
Much like in Scotland, it's difficult with the numbers that there currently are to properly estimate what the cost would be. The would be similar in terms of we would require to update our guidance, we'd require to think about training for staff, amend other internal guidance, and obviously if the provisions of the bill in relation to victim impact statements came in, that would incur a further cost as we looked at how we could roll that out, a further process.
I think that's us. That concludes our questions this morning. Thank you very much for joining us. And now the committee will move into private session, and I suspend the meeting for 5 minutes.